Yes, Mr. Pennington-Benton.
Thank you, my Lord. So we were just looking at Regulation 155, and I think we'd finished looking at 155 sub-regulation 5, where there's an obligation to include reasons why an eligible officer more experienced is recommended as being passed over. Regulation 156 is the recommendations must be made no later than 28 days before the acting appointment is to become effective. We've accepted that that's not complied with. Then Regulation 158 is obviously the critical one over the road or over the page on 1723. Again, in the margin, criteria for promotion, I think we all accept that that's not quite an ideal word. It's factors or considerations. In considering eligible fire officers for promotion, the Commission shall take into account, etc., etc. And obviously, 154 relates back to the same considerations that must be taken into account, first of all by the CFO and then later by the Commission based on the recommendees that are put forward. Now, just to be clear on one point, in Regulation 1581, yes, I'm just wondering if my friend Mr. Ramlogan's still around.
Yes, we seem to have a transmission problem. If you could just pause for a moment.
Thank you, my Lord.
We'll wait in court for 2 minutes, but if it's going to be longer, perhaps you can let us know. Mr. Ramlogan, we lost you for a minute or so. Are you able to hear us and see us?
I am now, my Lord, yes. Thank you.
All right. So we didn't hear any submissions while you were off air, and Mr. Pennington-Benton, if you could continue now.
Thank you very much, my Lord. So I was just dealing with the word eligible in Regulation 1581 because one aspect of the Court of Appeal's judgment that we don't accept as correct, even though it was in our favour, but we say it's not quite right actually, is that eligible in 1581 relates back to the job description. We don't think that that's right. In other words, it's not open to the Commission to say an officer is ineligible within the meaning of Regulation 1581 because they don't meet the job description. That's for the simple reason that the job description is created after the event. Doesn't have any statutory status.
Eligible means statutorily eligible.
Precisely, my Lord, yes, and we make that concession for that reason. What eligible does mean, possibly two things, but first of all, Regulation 146, so back 3 pages to 1719, the definition of eligible officer means an officer who satisfies the qualifications of an office. And although...
What's the qualifications of this office?
Yes, although it's not 100% clear, we think probably the correct construction of that is the qualifications that are set out in the fire service regulations that my learned friend, I think, briefly took your lordship to, which is
Regulation 9.
Exactly, and that's it. Now, having said that, the words eligible officer, that phrase, are not the words that appear in 1581, which are eligible fire officers. It's not exactly the same words. So that could just be a slip, but in any event, if it If it doesn't mean what 146 says it means, then what it means, we say, it simply means officers already in the Trinidad and Tobago Fire Service who in principle could do the job. I understand that's a bit soft around the edges, but it's flowing from a judgment of this court in a case called Ramator, trying to do the best the court could in that case without any other clear defined meaning. So we think it probably means qualifications, FSR qualifications, and somebody generally who is already in the service, so they could take up a promotion position to acting in the next post up, and in principle they could basically do the job.
And sorry, is Ramtool in our bundle?
It is, and I'm going to take my lord to it just shortly. So at all times, therefore, it follows that the appellant was eligible. Perhaps let's call this legally eligible, as it were, within the meaning of Regulation 1581, because that's why he was, entitled to apply, as it were. And therefore, the reliance on the job specification can only work if the fire service is entitled to impose minimum qualifications or minimum requirements of experience in the interests of the fire service, notwithstanding Regulation 158.
Notwithstanding Regulation 158?
Yes. So in other words, I can't get there through 158. I can't say, eligible means you meet the job spec and therefore it all ties together. I can't make that submission. So what I have to do is to say, no, even though you're eligible, the fire service can still shut your application down because in the interests of the fire service and public safety and all the other matters that the fire service takes into account, it's entirely, it's open to it to set down some minimum requirements.
Without reference to the Commission?
Yes.
Well, how can the Commission take into account the requirements of somebody if the fire service has shut them out? I don't understand that.
Well, I think I may as well move on to that.
I mean, 158 says the Commission shall take into account, doesn't it?
Yes.
I can see the argument that the Commission could say, well, we are going to treat something as a necessary prerequisite. I can't see how the fire service can say that.
Well, I think the only answer I can give to that is that these considerations, as a matter of implication, we say, are intended to apply against the backdrop of an employment position that has within it its own specific requirements. In other words, you take into account somebody's fitness, special qualification courses, experience, all the rest of it, but against the backdrop of an office or position that the fire service in its specialist expertise, because the Public Service Commission is a general commission, the fire service, in its own expert opinion, considers that there are some certain things that a fire officer in this particular position should have. And therefore, I suppose what I'm really saying is that these criteria, these factors rather, I'm correcting myself, these factors were not intended by the Commission. I mean, it's the Commission that makes these regulations. They didn't intend by making these regulations to prevent the fire service, qua employer, from doing what all employers do, which is decide some base requirements that somebody must hold for particular positions. That can't be right. And I should say, if it is right, I mean, it's pretty dramatic effects, because obviously job specifications are used across the board, not just at fire service, but right the way across the
certainly see the fire service, in conjunction with Commission, agreeing some minimum requirements. My difficulty is that here you're taking out of the equation the Commission entirely. But before going on to that point,
yes,
earlier on you said that when Mr. Lane was appointed, by virtue of the fact that he was the last man standing, as it were, there was no requirement on the Commission under Regulation 158 to consider any of these factors. Do I understand you correctly?
Well, they were entitled.
It would seem to me to be a total derogation of duty, not to, for instance, consider whether he's got demonstrated skills and ability relevant to the office. It would be leaving it entirely to the fire service, chief fire officer, or his devotion to duty. I mean,
I don't.
Are you seriously?
Yeah.
Sorry.
Sorry. Yeah.
Are you submitting that they can ignore these factors where they've only got one applicant that has been predetermined in effect by the fire service?
I don't think I am making that submission, but I suppose what I'm really making, I mean, this is a claim by Mr. Ramsaran, who was overlooked. That's the claim. It's not a claim by some other person in the fire service who says that they were in an equal position to Mr. Lane and that actually
and
Mr. Lane was
more directed towards what the Commission do.
Yes.
In the 28th of April. And
well,
they don't appear. Sorry, my understanding was that your submission was they didn't have to consider any of these factors at all on the 28th of April.
I don't think that's my submission. No, my submission is in this particular case that was not the claim that was brought, and therefore the evidence from Mr. Harrison doesn't cover what other considerations the Commission took into. I just don't know. But I think our position was there was only one person that qualified, met the job description. He was the only person that was qualified. And then the Commission's evidence is why the appellant wasn't appointed, and the Commission's evidence was because he didn't meet the job specification. I don't actually have any evidence, because it wasn't an issue in the case, as to what additional things the Commission took into account before retrospectively appointing Mr. Lane. I just don't know the answer to that. But if your Lordship's asking me whether somebody that meets the job description legally means that the Commission cannot go on and consider, on top of meeting the job description, the rest of the things in 158, I think your Lordship's right, they can't. And that must be right. And if I said something else earlier, that was wrong.
I mean, I have some difficulty with the idea that the fire service can impose matters by itself as a matter of job specification, which somehow precludes the Commission from considering eligible fire officers under Regulation 158. Because, I mean, it doesn't look as though the fire service is supposed to be a cutout, if you like, in terms of what gets through to the Commission. So one sees Regulation 153, failure of an eligible officer to apply shall not debar the Commission from considering him. So focus on the Commission. 154.1, the Chief Fire Officer only has power to make recommendations.
Yes.
And those have to be based on the criteria prescribed in Regulation 158. So that's looking forward to the sort of matters that the Commission itself would be looking at. So I would have thought that the natural reading of that is not that the Chief Fire Officer can himself impose specifications and then not recommend someone to go forward for consideration by the Commission, and that means their application stops there.
Yes.
There are two problems with that, as it seems to me. One is he only makes recommendations. He doesn't stop applications going through to the Commission. And secondly, his recommendations are themselves supposed to be based on the very criteria that the Commission itself is going to be applying.
Yes.
So, I mean, is that the wrong way of looking at it? Do you want to argue against that?
I do want to argue against it.
Sure.
I'm just thinking. I'm just giving some thought to it.
Because as I understand it, the thrust of your submission actually is that the Chief Fire Officer or the Fire Service can operate as a cutout,
yes,
as I've
yes.
been putting it, both
yes.
in terms of the specifications that they impose, and then if they don't make a recommendation of someone, as I understand it, you're saying, well, the Commission are not entitled to consider their application.
Yes, so I do say, yes, I mean, I certainly understand the natural reading of these two provisions, but I simply say one has to read those in light of the context, which is that the fire service is still ultimately the employer. The fire service knows the minimum specifications that are required in order to do the job, not the General Public Service Commission. And I suppose what we're really saying is, well, the Chief Fire Officer, or let's read the Fire Service, in creating a job description, is in effect giving consideration to those points in 158, but is saying, look, there are some red lines here. In other words, it's not fettering the breadth of the considerations in 158, but it is having regard to all of those, but also to the needs of the fire service, that these are some red lines. But coming to my Lord's first point, that recommendations don't stop somebody from going forward, but respectfully they do, because the Commission, subject to the list of people who have been overlooked, the Commission will only consider the recommendees. So it is a judgment-based filter, and it rests primarily with the Chief Fire Officer. So the Chief Fire Officer has to decide, who do I recommend? And if he doesn't recommend somebody, subject to, I accept, the safeguards in terms of overlooked people who can make representations, and the list of people more, the reasons in respect to people more experienced. I mean, there's a number of caveats to that. But the Commission, the Chief Fire Officer does have a filtering role. He does say, look, these are the people I recommend, and subject to those points, those are the people the Commission gets to consider. And then the Commission will say, okay, we're now applying these general factors.
But I mean, on that, I mean, a recommendation, I mean, could just be read as that. Here's a list of 5 people who are eligible, yes, who have applied. We recommend this person. I mean, that would be a recommendation. It would presumably carry weight because, as you say, the fire service is ultimately the employer. But you need to reconcile the fire service being the ultimate employer with the fact that the actual decision is to be made by the Commission. So under 1581,
yes,
I mean, the way it would be possible to reconcile the idea of the Chief Fire Officer making a recommendation with what 1581 says, that it's the Commission that actually decides who should be promoted, is to knock out your idea of the Chief Fire Officer being a sort of cutout, and that you only get through to the Commission if he's made a recommendation. But because as I understand, that would in effect mean that the practical decision maker as to who gets promoted would in most cases be the Chief Fire Officer, because he's only going to make one recommendation, isn't he?
We could make plenty of recommendations. We could make a list of recommendations.
But in this case, he just decided who was going to get the job, and nobody else was put forward, nobody else seems to have been considered.
Oh, Lord, I'm not diverting from that. I'm trying to deal with the point of law.
Sure, yes.
It's tricky.
Right.
and assist if I can. But my Lord, my understanding, my reading of these regulations is if the Chief Fire Officer makes a recommendation for 5 people, say, said, look, these 5 people are my recommendees, choose amongst them who you think should have the post. The people who are not on the list of recommendees are shut out.
Well, unless they've been informed that they can make
I accept all of that. No, I accept all of that. Well, but I'm just trying to make sure that on the point of law, because it's quite an important point of law, and there's job specifications are used across the public service, teaching, police, everywhere. So I'm just concerned, first of all, that this point wasn't run below. I'm not moaning about that, but that comes with certain difficulties. One difficulty is there was no evidence led below, and I haven't managed yet to get clarification on precisely the process by which job specifications are arrived at. That's because it wasn't a point that was raised below. So I'm just a bit nervous, respectfully, that this isn't a point that...
What was run below was, amongst other things, that the job specification was so ambiguous that no one knew what it meant.
I accept.
And well, the answer to that would have been some evidence from either the Chief Fire Officer or the Commission as to how it came to be brought into existence. And there is none.
Respectfully, my Lord, that's not, in my submission, quite right, because it was never said below that the job specification was, ultra vires or comprised of fettering of discretion. The only point of evidence that could have been filed, and which was filed, was what does the 6 years mean? How do we get to that? That's a separate point. But there was no challenge to Mr. Ramsaran in his affidavit, paragraph 16, accepts that there was a job description. He accepts the requirement. He never said, I don't accept the requirement. He said, I accept that's the requirement. His complaint was that he said Mr. Lane didn't meet it, and therefore...
He accepts it was part of the specification.
Yes.
I don't think he accepts its eligibility. But the point is that in a employment process, you work out in advance of a job advertisement as to what the requirements are.
Yes.
And doing so, you try to bring objectivity to those requirements. And so it would have been perfectly possible for the chief fire officer to say, well, I considered it, this is what I meant by it, we had a discussion about it, and so that it's not ex post facto trying to put it, trying to squeeze the facts into a particular definition. This was the definition we decided on in advance. There's no such evidence.
No. I accept that, my lord. I thought I was dealing with a different point, which was simply the varies of the job description as against the Regulation 158, which is a point of law I was trying to assist on. There's a separate question, which is how vague or not vague is 6 years senior management experience? Was it deliberately left to the discretion of the fire service to decide what that meant? And those are all separate questions I'm just dealing with at the moment.
Right. So, thank you. I was finding your submissions to deal with my point helpful, but I wonder whether it can be right, because I'm looking again at Regulation 155. This is page 1722.
Yes.
As I'm reading that now, it seems that things should operate in this way. 1551, there has to be notice to all eligible fire officers. So in effect, that's the advertisement or notice at the fire station.
Yes.
And then at 3, the chief fire officer shall allow a period of 7 days to elapse after the issue of the notice before forwarding any recommendations to the director for the purpose of allowing the fire officers to make representations in respect of that acting appointment. Yes. So that is contemplating, I'm a fire officer, I want to apply for the acting role, I send my, essentially, representations as to why I'd be a magnificent appointment to that role to the chief fire officer. And the chief fire officer holds off forwarding his recommendations to the director to allow for that to happen so that he can take account of those in deciding what recommendations to make. Then at 4, it says, where representations are made to the chief fire officer, the chief fire officer shall forward the representations in their original form to the director. Now, that makes no sense if the chief fire officer is going to be able to cut out people by his own recommendation. Surely the whole point about sub-regulation 4 is to make sure that the commission itself gets all the gets all the representations. It's true they're going to get a recommendation from the chief fire officer and therefore be the better informed as to what the fire service thinks would be a good appointment. But they're also going to have sent to them all the representations from everyone that wants to apply for that role. And then at 5, when submitting recommendations, the chief fire officer has to advise the commission of the reasons why an eligible fire officer who is more experienced than the recommended officer is being passed over. I think one needs to read that in the recommendation. Again, what's the point of doing that? Surely the point is that when one comes to what the commission has to do, it's going to have the recommendations from the chief fire officer, but also it'll be told other people have applied, here are their representations, and insofar as a recommendation from the chief fire officer is recommending that someone with less seniority, with less experience than someone else who has applied is being recommended, it gives the explanation of the chief fire officer for that. Yes. The point of giving that explanation is so that the commission itself can take that into account in making its decision. Isn't that how it works?
Yes, that's how it works.
Right, so, but that is to say that someone's application is going to the commission is not dependent on whether it's recommended by the chief fire officer or not.
Well, the recommendation goes.
Yeah,
my understanding of the way this
and the
works,
representations go.
Yes. So there's a recommendation. I see. Yes. So there's a recommendation for, say, persons 1 to 5.
Yeah.
number 5 on the list.
Well, in fact,
makes-
usually I think a recommendation means who do we recommend for the job, which,
I see.
perhaps ordinarily, I'm not saying you couldn't recommend more people, but ordinarily, if you've got an actual person that you think is best, that would be the recommendation. But that's a side issue. The point I'm putting to you is
Yes.
the structure seems to be 2 things get to the Commission:
Yes.
a recommendation from the Chief Fire Officer, but also the applications with the representations from anyone who has applied, whether they've been recommended or not. And insofar as the Chief Fire Officer, as I say, looking at sub-regulation 5, is himself recommending the appointment of someone who's less experienced than another applicant, he's got to offer an explanation to the Commission why he has made that recommendation.
Yes, I see. I suppose I'd read representations as against the decision.
But they don't know the decision.
Well, they would be told because...
Would they?
I believe so.
I mean, shouldn't it be...
Yes, so under 160, what happens is... sorry.
That's a vacancy in an office. We're dealing with the acting appointment, aren't we, under 155?
Yeah. Different process.
I think 155 is self-contained.
Oh, I see, yes.
So after the thing's been advertised, he's got to wait 7 days. And I think what he should have done is sent, after Mr. Ramsaran sent his application in May, it should have gone on to the Commission.
That's how I'm reading it
his
now.
representation as to why he should be given.
I see, in addition to the applications.
Yeah.
I see, so the
He
Commission...
didn't send anything to the Commission. Oh, he did. No, he didn't send anything in May to the Commission.
Not in May, he sent something in December, but I see. I'm afraid I'd read 158 with 160, but if your Lordship, yes, I see. So the point here is actually it's not just the recommendations. It's only the
I
recommendations.
mean, the only time there was an advertisement or the 155 notice was issued was in May, I think.
Yes.
Sorry?
And in that, as far as we know, after that, nothing was forwarded to the Commission after that. Mr. Ramsaran's application wasn't forwarded, no recommendation was forwarded, because they'd already been sent a recommendation in March.
No, there were 2 recommendations. One in January 2022.
Okay. Well, I say nothing after that. I mean, in the in the period in the aftermath of May.
Yes. So it was all after the.
It was all months later.
Correct. But anyway, just on this point, I'm just
before we leave that, in January, I think it's the 2nd of January, where there's a memorandum sent.
Yes.
And just remind me of the contents of that in the sense of, on a strict reading of 155, that should be the application by the appellant should have been sent. And presumably also in the intervening period, all the representations he'd been making, saying, by the way, look, I've got this qualification and this is completely, well, all the various factors that he'd been complaining about, they should all have been sent.
If one reads representations as being the application, but I'd read representations as being effectively after they've been told, well, look, we're not recommending you.
But they don't get told.
But
There's nothing that says they've got to be told
the
about that.
recommendation is disclosed.
So so if this is a self-contained code, then I think that must be right. The representations must be
Anything you want to say is
construed.
why I should get the job.
Yes, exactly. Construed wider than so to include an application or representation, that should all be sent on. Yeah. I suppose that must be right.
And it emphasises in sub-regulation 4 that it's the representations in their original form. In other words,
Yes.
The Chief Fire Officer is not allowed to outlarise, précis them or anything like that. He's just there as
Yes.
He's got to pass them on.
he's got to pass them on. So he seems to have 2 roles under 155. One is the recommendation-making role. I mean, strictly that's 154, but it's catered for in 155. But the other role is really to channel what's happening, because he's the head of the fire service.
Yes.
He's the one, I would imagine, that puts up the notice. Yeah, the chief fire officer shall notify. So that's him telling his workforce this acting role has come up. They send in their application and representations to him, but then, and he can take them into account in deciding what recommendations he makes, but he's also got to pass on those representations to the Commission. And that does seem to make sense of the structure of this, because 158, it's the Commission that's actually
Makes the
making
final
choice.
decision. So the Commission would then make the final decision
And it's
with
meant,
everything.
It's meant to do within 28 days of when it becomes effective. When it becomes effective, is that right? 156. Yeah.
And so
That's when the recommendation is to be made, but it's implicit. It's implicit in that obviously
So everything else
should go quickly.
Yeah. But again, even the fact you've got 28 days, the point of that, I would have thought, is to give the Commission time to make its consideration. Whereas
the implication.
if everything was going to turn on what the Chief Fire Officer thought should happen,
well,
potentially not.
yes. Well, if that's the correct construction of 155, and I see the points, I'm not sure I'm going to push back against it. It makes sense, but I'm not sure that necessarily means that the fire service still isn't entitled, when making recommendations, to impose what it says is the minimum requirement.
When did this acting appointment become effective?
Well, there's two different dates on that, but it's June. One's given in June and one's given in July. But it's from that period, June 2019 to the end of December 2019, and then there was a new, what's treated as a second appointment, but is actually just Mr. Lane staying in office, which is the 1st of January 2020 to I think the end of June 2020.
So they put out the notice probably in May in time, and then.
Yes.
Nothing was forwarded then within before the appointment became effective to the Commission.
Yes. Well, he was allowed to, yes, I mean, in principle, the Commission could have turned around, I suppose, in July or April 2020 and said, well, we don't approve the appointment of Mr. Lane. Quite how one would then approach Mr. Lane and say,
there wasn't any further recommendation of him in May. There was only the recommendation already made in March.
There's a recommendation in March. He assumes office. Then there's a recommendation retrospectively in January 2020. There's another recommendation in February 2020 for the next period, and then the whole thing is considered in April 2020.
None of Mr. Ramsaran's representations that he made at any stage were ever sent to the Commission.
I don't have any evidence to suggest that they were, no. And then in July 2000, and then a decision is made on the basis of Mr. Harrison's summary of that meeting that, well, Mr. Lane met the job spec, Mr. Ramsaran didn't, and that's it. And that's either a complete answer or it isn't. And if the job specification isn't, if the fire service isn't entitled to lay down some red line minimum requirements in a job specification, I still maintain, if I can, that it is. Because ultimately, even if 155 does work...
Pushing at an open door if you do it in conjunction with the Commission. But cutting out the Commission seems to me completely...
Well, as I say, one of the difficulties is this is a point that was first raised in my opponent's case before...
Well, you're relying on the job description.
We've always relied on the job description, but there's never been any challenge to the virus of it. No one's ever said that we're not allowed to apply the job description. Mr. Ramsaran's case was, oh, I didn't meet the job description. Yeah, but no, neither did Mr. Lane. It just wasn't his case. The first time this point has been raised, the interesting point there is in my learned friend's case. Now, insofar as it's a pure point of law, I've got on and dealt with it as best I can. But what I don't have, and I've asked the Attorney General, and we're waiting for instructions still, because there's a lot going on in Trinidad, is concrete instructions on precisely how the job description is arrived at. But my understanding is that Your Lordship, my Lord Stevens, is right. I don't know if it's approved by the Commission, but it's certainly devised by the Fire Service. I believe also in conjunction with the Trinidad and Tobago Fire Service Association. So I think these job descriptions are agreed by the associations as well, and that's certainly how the police service job descriptions are arrived at, they have a negotiation with the associations, the employer associations, and they decide what these should include, and everybody accepts that that's the minimum benchmark requirements. And what I simply say is it can't be right, however one construes these regulations, that the Commission intended to prevent any of the services from laying down some absolute sort of benchmarks. It's no good saying, well, okay, well, they could perhaps juxtapose not having this training course against having some other factor. The Commission is obviously got to look at those requirements in the context of, it's got to look at those factors in the context of the requirements of the office, which are ultimately for the fire service to prescribe, we say. And yes, the effect of that may be that it cuts down, in a sense, on the Commission's broad discretion, because it's looking at all of those factors against the backdrop of the minimum requirements of a fire service. But there's nothing surprising about that, and it would be surprising, I suspect, respectfully, to the Commission.
Why did the Chief Fire Officer say that he was eligible?
Well, that's...
Because qualifications.
That's another separate, respectfully point. I mean, I don't want to get... I accept procedurally things went wrong, but I've got a limited amount of time to try and assist on what are important points of law. I accept the bad bits. There's not much I can do about them.
And was the Court of Appeal, the Court of Appeal at page 599, paragraph 33, said that Mr. Lane was appointed to act as Deputy Chief Fire Officer in July 2019. But I haven't found any evidence to support that conclusion at all.
No,
Apart from the fact that he walked into the office and sat down.
The correct conclusion is the
He was appointed retrospectively, I think. Is that right?
The correct conclusion is that of the High Court judge at paragraph 92 of her decision, which is her ladyship's decision, which is at 382 of the bundle.
Well, I don't know how the Court of Appeal came to the conclusion that he was appointed in July 2019, when the only body that could appoint him was the Commission.
Retrospectively.
And they hadn't done anything about it.
Well, retrospectively. They're basically saying that he was appointed with effect from June 2019 by way of a decision made the next year. That's what they say. It's a retrospective appointment. That's it.
And had he done 6 years of managerial experience by then?
Yes.
Well, why did you say in the letter that he hadn't?
Yeah.
The letter is an error. The evidence is clear, and that's the evidence that was filed at court, was that he did indeed comply with the 6 years at senior management level. So the difference between the parties is if one starts to acquire 6 years management experience at the level of DFO, Divisional Fire Officer, including acting Divisional Fire Officer, then Mr. Lane had about 7 years and 2 months senior management level experience as of May 2019. But Mr. Lane had about 3 years, 9 months, something like that.
The appellant had 3 years, 9 months.
Sorry, who did I say? Sorry.
You said,
Sorry, Mr. Yes, the appellant, exactly. Whereas if the appellant was correct that one starts to gain senior management level experience from the post below DFO, which is
the third.
a DFO, assistant to the divisional fire officer, then he would have met the 6 years. But the way it's being calculated shows that the practice, at least in this competition, was to compute the 6 years from the post of DFO upwards.
The practice...
So may I just... Because I keep slipping from one subject to another, I just want to make sure I've covered what I need to cover in my time. Sure. So I think I've done, have I, my Lord, what I need to, I mean, rightly or wrongly, I can't take, I don't think there's anything more to be said on the fettering.
Okay, I just wanted to ask about one last question on that.
Yes.
You assert, in effect, that the fire service is entitled to lay down red lines. But, I mean, it might be said it's actually difficult to find a power for the Chief Fire Officer or the fire service to do that if one's, I mean, presumably you'd have to say that, what, where does one get that from? Regulation 154?
No, I just say it's just in the nature of the context of being the employer, and that these regulations weren't intended to prevent
Right,
any employer.
but isn't the point that can be put against that if you look at the structure of this particular bit of the regulations, since it's the Commission at Regulation 158, which has to do the considering of people for promotion, if it were the case that the fire service itself, whether it be the Chief Fire Officer or the service in some other manifestation, could lay down red lines, cutting out people who were eligible, that would be to prevent the application of those red lines, would prevent the Commission doing its considering under 1581.
Yes.
So that seems to be an argument against there being.
It is an argument against it, yes, an argument.
Okay, I just wanted
accept
to make sure you'd had a chance to say what you wanted.
It is an argument against it, but
All right, that certainly satisfies me on the regulations.
I'm grateful, thank you very much. That's that point. Can I just see? Can I just give your lordships the reference for the 2nd of January 2020 recommendation? That is at page 920, just so you, whoever has the pleasure of writing the judgment knows where it is. That's the 2nd of January retrospective recommendation, and that goes through to 923 for those periods.
Did you say there was another one in February? Or was I...
Yes, indeed, there is another one in February. That's at page 935, and that's the recommendation that Mr. Lane act from the 1st of January 2020 to the 30th of June 2020. So that's the second, which is only partially retrospective in as much as there's obviously a period after the 28th of February to which that recommendation would apply, but there's no advertisement and therefore no representations made from other eligible officers. And as I think I've accepted, the difference really between where we are and the Court of Appeal's judgment is the Court of Appeal's judgment, the Court of Appeal was treating the job description as a question of eligibility. And that's why they say, well, if you're not eligible, what's the fairness complaint? And we say, no, he was eligible, he just wasn't suitable because of the job specification. And that's the conclusion that was reached at the April 2020 meeting, and it's either sustainable or not. But that's.
Can you remind us of the evidence? It was Mr. Harrison's evidence.
Yes, indeed, my lord. So it's Mr. Harrison's evidence, paragraphs 18 and 19. It's at 888. That explains what happens at the April 2020 meeting without appending any notes of it, but explains what happened. And then the formal appointment of Mr. Lane is at 939, and one can see the periods of the appointment at 944. So the submission would be subject to the fairness point, subject to the procedural complaint. The CFO and the Commission were correct, we submit, that Mr. Ramsaran didn't meet the requirements of the job specification. First, because he didn't have the brigade course qualification, and then later on because he didn't have the 6 years of senior management level experience. I've set out in our case why and how we say the 6 years was calculated. I'm minded, unless anybody wants me to, not to trawl through that here because it's quite forensic, but one can see in our submission that in fact in this case it is plain that the Commission was calculating the 6 years as running from the position of DFO, not a DFO.
I don't think Mr. Harrison says that in terms, does he?
No, that's why it's a bit forensic. One has to go, so the two job histories are appended to Mr. Smith's affidavit, and one has to go through and count it all up. And if you do go through and count it all up, one gets to the answer.
Could you at least give us the
Yes.
paragraphs of your case?
It's not much fun, but anyway, so the appellant's employment record is 859. That's appended to Mr. Smith's affidavit. And by the end of 2019, one gets to 4 years and 9 months in a senior management level post. So that's acting DFO, DFO, ACFO, acting ACFO, CFO. So in any one of those combination of posts, you'd acquire the senior management level experience, and he gets 4 years and 9 months by the end of 2019. Obviously, in May 2019, it would have been slightly less. Mr. Lane's employment record is at 862. And by May 2019, he's just shy, I think, of... In fact, I think actually it might be slightly over 7 years, actually, on a proper calculation. These... Bear with me just a moment.
So where does it, on this list, which role does it, do you say the calculation starts from? I mean,
Right, so if one goes to 859...
acting in the rank of...
Yes.
I think you told us ADFO and above.
ADFO.
Sorry, not assistant to the DFO, it's DFO and above. So it's acting. So basically, if one looks at 859, this is the appellant's. We say at the top there, acting in the rank of assistant to the DFO. We say no, because an assistant to the divisional fire officer is not a senior management.
Yeah, okay.
Because he's an assistant to the DFO. So a divisional fire officer is somebody who, unsurprisingly, is in charge of a division with several fire stations within it. And the basic point is, well, he's an assistant to a DFO. That's not a senior managerial position.
Okay.
But at DFO, the actual divisional fire officer, including acting appointments, so the next heading down on page 859,
Which
all
is
of
period for acting in the rank of
Yes.
of DFO.
Yes, all of those periods would count. So if one adds up those periods, it comes to just over a year.
Okay, thank you.
And then if one adds up, and of course once Mr. Lane is in the appointment of DFO, in the position of a DFO, obviously all of that time counts because that's a senior management level position.
Right.
And what Mr. Smith was saying, although his statement, as I accept, is not brilliantly clear, he was basically saying, look, Mr. Lane had acquired experience acting in certain positions within the senior management level territory, that if one turns to 862, so Mr. Lane is at 862, so he's acting in the position of DFO, but also ACFO, and over the page DCFO. So the point being made in Mr. Smith's affidavit
Is all those count for Mr. Lane?
Yes, but because the appellant didn't have those. So in other words, we all accept that within the Office of Divisional Fire Office, Mr. Ramsaran was the senior officer because he'd been appointed 4 days ahead of Mr. Lane. But that actually Mr. Lane had more senior management experience because he'd undertaken numerous acting positions in the posts of ACFO, DCFO, and before he was appointed a full-time DFO, acting DFO, and therefore he had more senior management experience. That's basically the point that was being made, if you add it all up. But obviously, Mr. Ramsaran's original complaint was, oh, I'm more senior. And of course, he says, well, I've seen other officers being appointed to positions based on seniority, and therefore, hang on a second, why are you now changing the goalpost? To which we say, we're not changing the goalpost, this is the job specification. If nobody meets the job specification, then we might go on seniority, which is maybe what happened in the past, which is what Mr. Smith says in his paragraph 35.
And tell me something, then you agree with a calculation carried out by the first instance judge at page 381, paragraphs 86 and 87, that if you change the criteria to the ones that to the criteria that she applied, then the appellant had 7 years, 3 months and 10 days in the requisite posts.
I couldn't promise to the day, but yes, if you take into account ADFO as opposed to DFO,
Yes.
then I agree.
Well,
yes,
yeah.
but the judge was wrong to do that because it's DFO and above that counts. We say.
So a DFO means assistant. Sorry, assistant.
To the DFO.
Right.
Yeah,
Okay.
that-
Where does Division 1 kick in? Oh, sorry. Is that not
No.
the question?
The trouble is, the job description never said experience acting in the DFO or above.
Well-
It just said senior
Yeah.
management experience, and it looks as though they picked after the event on the one that
No.
gets in Mr. Lane and cuts out the appellant.
It's not. That's not how it works. It is the established practice, but
Established
what-
practice in
what-
this application or in previous applications?
I think previous applications. Can I make that point? I can make the point by reference to the job descriptions actually. So if one looks at, and as I say, this is in my case. I realise I'm going to answer my Lord Borough's question in a minute as well. But page 903 in the bundle.
This is in your case, is it?
No, sorry, this is not in the case. This is in the record. But these submissions are in my case. But I'm going to go through it now if it's of interest. But no, I do say that it's the general practice, which is supported by just about. Well, it's not the best evidence of us, but it's supported by the job description. So if one looks at the job description for Deputy Chief Fire Officer, which is at 902.
So sorry, could you just tell us where in your case you deal with it? I'm not asking you to read it, but just that we know where to find it.
Yes, it is in it's the third issue, so page 1101 onwards.
Thank you.
And I say a number of things point to DFO being the starting position, not least that it is a senior management position because it's a management position above managing a fire station, which is a Division 2 job. But I also say that if one looks at the job description at 902 for DCFO, on 903, it says there 6 years at a senior managerial administrative level.
Right, 903.
903.
At the bottom of the page.
At the bottom of the page, that's the requirement.
Sorry, which job specification is this?
This is for DCFO, so Deputy Chief Fire Officer.
This is the job specification for the job for which he applied.
Correct.
Yeah.
And that uses this expression, senior managerial level experience. Now, if one then...
Does it say anywhere in it, by the way, this is an eligibility requirement. If you don't have it, you don't even get past go.
No, it doesn't say that on this piece of paper. But
Does it give any weighting to any of these issues, apart from putting some of them in bold? Expert knowledge of fire service disciplinary code is in bold, and other things are in bold. But is there any weighting provision
No.
at all?
No. These are just black and white requirements, and the
How can you
practice...
say on the basis of that job description that it is a eligibility requirement, as opposed to a factor which will be taken into consideration along with all the other factors, such as knowledge of rescue tactics and techniques and first aid practices in emergency care?
simply based on the fact, A, that this is a black and white requirement, as
But they're all
opposed to...
black and white.
Well, they're not, because there's a degree of evaluative judgment as to whether somebody's got expert knowledge of this or working knowledge of that. These are black and white. You've either got 16 years experience at the right level or you haven't. And that's why the practice, and there is case law, there's previous cases that have been brought by this appellant where these particular two requirements are treated as requirements over and above the qualitative, evaluative stuff that's in the spec. The black and white ones are picked out and used as specifications.
Well, Mr. Ramsaran's put in evidence of past appointments of people who didn't satisfy these.
Yes, to which the answer is paragraph 35 of Mr. Smith's affidavit, where he says, well, if there's no one who meets the job specification, then we look at different things. But
To say that's black and white, to my mind, is a little bit difficult, because you don't know what senior managerial administrative level is. And least of all, the applicant doesn't know, or objectively, how do you judge that, unless you actually bring definition to it?
yes, well, my lord, I accept that point, and I think all I can say about that point is the practice, I haven't forgotten, but the practice it has been to treat senior management level experience as starting at the DFO position. And the phrase is used here, senior management level experience. If one then turns to 1101, which is my case.
I'm sorry, I can't avoid it.
Yes.
But the fire officer actually said that he was eligible. He met the criteria.
Yes, he did. He said that at one stage.
So I'm not certain how you get a practice.
Which was unknown to the Chief Fire Officer.
Which was unknown to the Chief Fire Officer.
On the 31st of January, he said, 2020, he said that Mr. Ramsaran met the job spec because he had done the IBCC course. Later on, a month later, in fact, he recommends Mr. Lane, and then he deposes an affidavit saying that actually the correct position is that he needed the 6 years. So the inference is that in between his initial thought, because that's also consistent with his initial refusal in May 2019, he thought that the only requirement that was missing was the IBCC, and at some point...
I think the inference is he was making it up after the other.
Well, I don't agree with that, my lord, and the inference is that somebody pointed out that there is a 6-year management experience, senior management experience requirement, and that was then applied, and that's consistent with all of the documents.
If it was a serious requirement, it must have been a serious oversight on his part.
It was an oversight because the original refusal was just on the basis of the IBCC, to which actually further considerations needs to be given to both aspects of the job specification. I mean, there's been previous litigation on these sorts of requirements. Indeed, the appellant himself has brought a previous claim in relation to a refusal on a 5-year period. Anyway, it doesn't matter. Point for present purposes is the phrase senior managerial level experience is used in the DCFO job specification. And if one turns to 1101, which is my case, these are the lists of the officers in the first division. And if one looks at where the DCFO position is, second from the top, we say that senior management level experience can be gained at the divisional fire office level and the assistant chief fire officer level, acting or permanent, doesn't matter. And therefore, that's why the deputy chief fire officer job description says senior management level experience, because it could be acquired in any of those 3 posts. In other words, acting DCFO, ACFO or DFO. So that's why it uses the phrase. Now, if, however, someone is applying for the position of assistant chief officer, the only role they can gain the requisite experience in is a DFO, effectively. And that's why, if one turns to the ACFO job description, which starts on 897. One turns to 898. The experience level changes to 5 years at the level of DFO, because that's the only level left within the senior management level catch pool, as it were. So that's these job descriptions, broadly at least, do. It doesn't answer my Lord Stephen's question, which is, was any of this sort of communicated to would-be applicants? But the practice is, in any event, certainly, or is apparent from these documents, that that's how it's calculated. But certainly that's how it's calculated in this case.
I'm not sure that I followed the point you were making on the change to 5 years rather than 6 years.
It wasn't a change from 5 to 6 years. It was just the change in the language from senior management level experience.
Where do we see this?
So
898.
it's not a very interesting point, but at 898,
Oh, I see.
yeah, the language changes. So in order to apply for the position of ACFO, it doesn't say senior management level experience anymore, because it doesn't need to. So it just says DFO, because that's the only position in which you could actually gain the relevant experience. So
you say this is established by practice. What are you relying upon?
that
This?
this and the fact that that's how one can reason backwards from the calculations, as I say.
Does anybody give any evidence to say?
Yes, well, as I say, Mr. Smith is, in his affidavit, is explaining, although, and it's Mr. Smith that appends the employment records, and he explains in his evidence, paragraph 6, which is on 848. So paragraph 6 on page 848, he sets out he says that I've appended the claimant's various appointments list. That's what we've just been looking at. And then Mr. Lane's employment list at paragraph 7 that we've looked at. And then he explains in paragraphs 8 onwards, and in particular at paragraph 10, the point he's trying to get at. Mr. Lane has more senior management experience. He's acted in the offices of ACFO and DCFO. The point he's trying to get at, and again in paragraph 14 on page 849, is that although the claimant, now appellant, was promoted to DFO ahead of Mr. Lane, in fact Mr. Lane had acted in these various senior positions and got the senior management. That's the point that he's making there. He doesn't do the maths, but that's what he's saying. Mm-hmm. And then someone did do the maths somewhere for the judge below, but I'm struggling to find a reference at the moment. Can I just deal very quickly with the divisions? The first and second division offices are set out in the Fire Services Act in the schedule. That's at 1581. Was it 1581? So these are the two divisions. I've been myself through the Fire Service Act to try and ascertain what particular significance these divisions have. And other than for the purposes of salaries and pensions, look at section 17 and 18, don't need to go to them, but they're slightly different pay packages and retirement ages. In fact, if you're in Division 2, presumably because it's a physical job, you actually get to retire earlier than the people in Division 1. But other than that, it's not possible to say, for example, everybody in Division 1 is, a senior management person and everybody in Division 2 is not. All that can be said is, well, the fire station officer is obviously in charge of a fire station in Division 1, and then in Division 2, fire station officer and the substation officer are management roles within the second division, but we would say they're not senior management roles, whereas once you get to the divisional fire officer, you are in a senior management role because you're in charge, you're above the station, you're now looking at regional management functions consistent with the jobs above that, ACFO, Deputy Chief Fire Officer, which are obviously regional
Where's
management.
the brigade engineer fit into all this?
That, I was hoping no one was going to ask me that question because I don't know, I'm afraid, is a short answer, exactly where that person fits in. I think it's an engineering role and maybe sui generis, but what I don't know, I'm afraid. In respect to the third officer, I'm inclined...
So I think you did tell us before, looking at paragraph 38 of your case,
Yes.
that the senior management positions began at divisional fire officer. So
Yes.
on that, brigades engineer is
On
not...
Mrs. Smith's schedule at 856.
It's slightly different.
Tree.
It's a different tree. No, I know. And I think all I can say is I've done my best. I have done my best. I've been sleeping with these papers for about 5 days.
How about the job applications for the third officer? You say, well, that's just an assistant to somebody and doesn't really have any real senior manager role.
Yes.
It might be interesting to see what the fire service describe when they ask somebody to be a third officer.
Yes.
Do we have anything like that?
We don't. I mean, I have seen those adverts, but not in respect to the third officer, because just to make things even more complicated, that in fact is an obsolete office now. And in fact, it's basically the assistant divisional fire officer. My learned friend, quite rightly, I think, says...
The governor
it was the
made the amendment.
The schedule wasn't amended.
Well, okay. Well, then
Yes,
your case is that the whatever the third officer is now called isn't senior management. Okay. It might have been useful to see
Yes.
what the fire service described them as when they
Yes.
ask for applications. You have to have abilities to manage on a senior basis. You'll be based
Yes.
in a certain place. Is there any such evidence?
There is no... I have seen, I don't want to
Yeah.
tell you what it says, because that would be unfair to Mr. Ramsay, that there are job descriptions for the position of ADFO, yes. I've seen those job descriptions, and they are not in evidence. So, my Lord Burrows, I don't know if that
No, that's fine.
adds anything
Very much.
of any particular moment, but so that's that.
Do you accept the proposition that was being put forward on behalf of the appellant that if there is a right of appeal or a right to make representations, that somebody should be informed about that right expressly?
I can see the attraction in that proposition, but I would need to remind myself, because I have a feeling...
Well, if the representations include his application, I mean, in a way,
Then it doesn't,
he doesn't need that because anything he'd sent in was meant to be
Yes,
forwarded.
yes, so
And indeed, he did put in an application and he sent some letters and
yes, but
those were representations.
those are representations. But in answer to my Lord Stephen's question, I may as well answer it anyway. I can see the attraction at that point, but I have at the back of my mind the possibility that I think there's something somewhere that says they have to familiarise themselves with regulations, and therefore I wouldn't want to answer off the cuff, because I suspect actually, certainly in the position of a DFO, one would expect him to be familiar with the process.
Well, it looks as though in 155 it's meant to work. You get told there's the appointment to be made, of acting appointment, and then that is your notice to make what are referred to as representations.
Yes.
Anything you put in is a representation. So on that basis, you are notified of the opportunity to do so.
But maybe it might be said you should be told you've got 7 days to do this.
Yes.
Yes.
Because otherwise you might miss that opportunity.
Well, that's true.
It seems on the chances of the recommendation being made within 7 days seems quite slight. But yes, I take the point. But yes, But if that's why I'd read representations as being something that somebody says in response, because that's the normal use of the word representation as well. Have you made, as opposed to simply saying any materials submitted by an applicant should be forwarded to the Commission. I don't know why it doesn't just say that if that's what it meant. I'd read it as application first, any moaning in response, plus the recommendations has to go off to the Commission. That's how I'd read it, but I can see, having enjoyed the exchange earlier, that may not be quite how it operates. That's how I'd originally read it, that representation was effectively somebody complaining.
Certainly if you were concerned about the interests of the employees, to use that term, one would think that it would be the sort of case where they should be told the time period in which they've got to make their representation.
On the job advertisement, but if the representations includes your application, then all you need to know is the time limit on the job advertisement.
But they may include that, but you may want to, I mean, this is specifically looking forward to you making something more substantive than just, I would like to apply.
Well, I don't know, because, I mean, if representation
is something more substantive than I would like to apply.
It could be, but I mean, I'm struggling at the moment to understand why the word representation. I mean, representations is either something you make in response to an adverse decision, or it's your application materials, isn't it? I don't understand why we're talking here about representation. I mean, you just make an application, don't you? And that's that. And then you either get told you're being recommended, or you get told you're not being recommended. And if you're being told you're not being recommended, you can put in some representations, and everything goes off to the Commission.
If you take it to its logical, all the way down the line, as it were, for it to be of any use to the Commission, the person who's making the representations should be told that it's going to go to the Commission, and the points are going to be considered by the Commission, and it's going to be informative for them, and so therefore make full representations. Otherwise, the Commission is not able to exercise its own independent judgment.
Yes, so the advertisement is at 870. So it's a case of deciding, I suppose, what one adds or subtracts from that. Perhaps the addition of the words.
Well, you were told you have to submit your application by 17th of May.
Exactly.
According to the statute, you might have missed your chance for representations, and the recommendation might have winged in before that, within 7 days from 6th of May.
It's a minimum of 7. So, I mean, by opening it up for a longer period, there can be no injustice to applicants, can there? It's obviously open to the CFO to open it for a longer period, plainly. There's a minimum in the regulations, and it's open up for a bit longer, and there's nothing wrong with that, we say. And obviously, for the reasons I've already gone over, we say you can rely on a...
yes, I see. It's when submitting the recommendation, so that's the thing that you've got to have made to recommend the representations.
I believe so, yes.
Well, Kieran had already submitted the recommendation in March, so, according to him.
Yes.
According to Smith, I mean.
Can I just very quickly turn to the decision in Ramator? That's in at page 2154. So this is going slightly over old ground, but I did promise to turn it up.
And you're going to this for what proposition?
Just literally to make your lordships aware of this decision and how it impinges upon the question of job descriptions and so on. I mean, I could just alert your lordship's attention to it and invite your lordships to read it, to be honest. I don't know which really particular.
Which are the relevant paragraphs?
So,
which points you want to...
It's a very, very short judgment.
So isn't this the one on, was it Regulation 26?
Yes, that's right.
Which doesn't apply?
No, it doesn't, but it's the basis of my submission, as against myself, as in a sense, that eligible in Regulation 158 can't mean what the job description says. I think earlier on, my lord, when we were having an exchange, your lordship asked me about the Ramator decision, and this is it.
All right.
And that supports, although although it's an analysis by Lord assumption of Regulation 26 that doesn't apply, I say it is analogous for the proposition that the word eligible in Regulation 158 can't be a reference to a job description, but it is distinguishable for the other proposition, which is that, or it just doesn't say anything about the
This is paragraph 13 on page 2160. That's the point, isn't it?
yes.
I think you've already disassociated yourself from what the Court of Appeal said about
Yes,
eligibility.
I just wanted to make sure that
That's probably sufficient.
yes. Well, in terms, I don't really, unless your lordships want me to have anything more to say on the facts. I mean, they are what they are. The first instance judge's decision that there was no breach in respect of the first period, that is to say the first appointment, was on the basis that it was accepted effectively that the IBCC was a necessary qualification. We submit that that is correct, but obviously it hinges upon me being allowed, as it were, me being entitled to impose red lines, is the phrase I've adopted. So again, the judge is either, and the Court of Appeal are either right or wrong on that first period, depending on whether or not I'm entitled to rely on the job description.
So can I ask you this? If they're wrong, if we conclude they're wrong on that first period, what are the consequences in law of that? Are you going to deal with the constitutional complaint?
Well, the consequence, so in respect to the first period,
My understanding is that the regulations govern the process.
yes,
And if they have been breached, then the process was unlawful.
yes,
And so legitimate expectation, constitutional principles are neither here nor there because the matter is determined on the basis of the regulations. And
yes,
for you to succeed, you've got to establish that the job specification was an eligibility requirement.
but I think,
Devised and adopted in such a way that it was a lawful eligibility requirement.
yes,
And if you're unsuccessful in relation to that, then there has been an unlawful disregard
yes,
of the appellant. He's entitled to a declaration to that effect, and he's entitled to whatever damages ultimately would arise.
Well,
Though,
that's-
of course,
that's- yes.
on his damages claim, he would have that uphill task of establishing that if his application had been considered, it would have stood a viable chance of succeeding.
yes. Well, I understood my Lord Sale's question to be more nuanced than that.
In essence, I'm asking,
yes,
is there a damages claim?
exactly. That's what I understood my Lord
If
was saying.
it's
See,
a pure breach of
Exactly.
administrative law, you don't get damages for that. I don't believe, even
You don't,
in
no.
Trinidad and Tobago.
Even
So
in-
the question is whether it's a breach of a constitutional right.
yes, exactly. That's what I understood the question to be.
And then, as my Lord says, even if it's a breach of constitutional right, you'd then be into matters of causation and so on, I would imagine, although I think there's a claim for vindicatory damages as well.
The problem is there,
What is your case if we're against you in the first period?
in the first period,
The lawfulness of
it depends why your lordship was going to, but yes, if we were never entitled to apply the job specification, then we would obviously accept a public law error, breach of legitimate expectation or an unfairness, something like that. And in respect to the constitution,
regulations, wouldn't it?
or breach of regulations, but not
Law
every.
breaches anyway, would you accept, I think, the
But not every breach, as I understand it, not every breach of the regulation necessarily renders a decision vulnerable to a declaration that was unlawful, I think. But anyway, I'd accept in this case, if we applied the job description as being a cutout when it wasn't a cutout, then that would obviously be a public law breach. As to whether it's a constitutional breach, it's complicated because my learned friend's case on protection of the law was simply that all of the criteria applied throughout both appointments was so vague and uncertain that there was a breach of the protection of the law. I don't think there was a separate claim that there was any constitutional breach just because they wrongly applied a job specification to him. So I'd have to sort of almost imagine what that constitutional claim would look like and an answer to the question.
Is there a pleaded constitutional claim? Let's start.
There is a pleaded. There's two pleaded constitutional claims. One in
Can we
respect to
look at those
yes,
very quickly?
yes. So the amended fixed date claim form starts at page 80, and I think we get to the breach of protection of the law at page 87. So that's the breach of the protection of the law claim, 87 to 88.
So when it's put as breach of the protection of the law, is that breach of the constitutional right in section 4B?
Yeah, yes.
Page 2484. That's what that is referring to.
Yes, so that's correct, yes. And that appears, as I say, to be a general complaint that all the provisions were unclear and therefore arbitrary.
So if we decide that the Chief Fire Officer and the Commission have failed to apply the procedure in the regulations, and the effect of that has been to cut out the appellant from consideration for the acting CFO job, whereas he should have been considered.
Yes, I say that's not a breach of the protection of the law.
But why not? I mean,
Because he
this
had
is-
a remedy, which was judicial review, and therefore, although it took him to this stage to succeed on that claim, it's an answer to a
Surely
protection.
you're principal entitled to damages on some basis, aren't you? If you've
Not-
if you've never been considered for the job when you should have been, I mean,
Well, you may be in a
that
common
must be
in a common
question
law.
what chance he would have had, or something.
In a common law claim, I
Yeah.
mean, if he'd have made a common law claim in his judicial review claim, maybe, but not the constitutional protection of the law claim.
Right, but I mean, just reading the words of section 4B,
Yes.
he's entitled to, as a fundamental human right and freedom, the protection of the law. And he hasn't had the, I mean, on this theory, he hasn't had the protection of the law. So it seems to fall
Well,
within that, unless you
Yes, I
have
think
some authority that explains that that's to be given a particular meaning.
so.
The judge held
Yes.
judicial review was an
Exactly.
avenue available to him, but judicial review doesn't get home in relation to damages,
Right.
you say. Is that right?
That is correct.
Yeah.
Yes.
Well,
So
then he's deprived of the protection of the law in relation to his damages claim.
that's the only way in which one. That's not the way the case was put, but that is the only way in which I think I thought myself one could put the claim, because judicial review is the ordinary remedy if somebody just gets the law wrong. I mean, what you need to show in a protection of the law claim, because don't think we're talking here about legal systems, and there is, as part of the legal system, an effective court process, and therefore it's pretty difficult in most circumstances to say you haven't had the protection of the law if you can go to a court and get the protection that you need.
Judicial review, ordinarily, you would ask the decision maker to remake the decision.
Yes.
And, but he can't do that here.
No. So the judge at first instance said, paragraph 112 onwards, so 389 onwards, deals with the protection of the law claim. And it all turns in the end on whether the judicial review process is an effective remedy. And I suppose the judge's decision at first instance at that stage, assuming she was right to grant relief in respect to the second stage but not the first stage, is that gives just satisfaction. But the 2 points, yes, I suppose the 2 points that could be taken against me as well. There's no damages available in a judicial review claim simpliciter, although it's open to somebody to make a common law claim.
But, sorry, I'm looking at paragraph 113 in the judge's judgment, which is quoting Lady Hale. True, she's talking there about equality before the law, like the right to equal protection of the law. But, I mean, affords every person protection against irrationality, unreasonableness, fundamental unfairness, or the arbitrary exercise of power.
That's right.
Well, hasn't there? I appreciate you can't accept that the premise is correct, but just for the purposes of argument, if there's been a failure to operate the regulations in the right way, with the effect of cutting out the appellant from being considered for this post, whereas he should have been, is that not fundamental unfairness to him, or the arbitrary exercise of power in relation to him, so that he is within Section 4B?
My Lord, it's the right sort of complaint, but it is subject to this point about whether judicial review is an effective remedy. So I think that the two cases are, going back to my case, are Achille Charles. Well, can I just take Lordships to my case, which is at 1111, paragraph 66. It's those, I think, are the relevant decisions. It's about whether judicial review on the particular facts of the case provides an adequate remedy. And I dare say the 2 points that would be taken against me as well, you can't get damages.
But could he have claimed damages or not? Perhaps not. It's not a contract of employment case. Yeah, I don't know. It's a public position, so
It could be a Crown, exactly, it could be a Crown appointee. I don't know, is the short answer. He could be a Crown appointee, therefore he may not have a contract of, may not have an exercise
And
right.
certainly it's not being put
Pleaded.
to us on the basis it's a contract case.
no, there's a damages claim.
But it's never been...
It looks like a straightforward judicial review claim, potentially.
Well, you don't get money compensation.
No, you don't get money, but usually if you act promptly to claim judicial review gives you a sufficient remedy. So one wouldn't necessarily say just because you didn't get a prompt remedy in judicial review, if you had the opportunity to apply for one, that there would have been a breach of your constitutional rights. But I'm now trying to get the timeline in my mind.
Yes.
So when did he learn that...
I think he applied for judicial review in August 2020, didn't he?
Yes.
So
pre-action went on in June and July, and then I believe your Lordship's right.
He certainly acted promptly at that stage.
That's not really the complaint. There's no, because he gave a very long affidavit explaining why he'd waited, and I don't think that was ever really challenged. It's not that he didn't bring the claim promptly. It's just simply a question of whether it's sufficient in this case for there to be granted a traditional judicial review remedy, or whether, given that he's now left...
Yeah, so when, can you remind me, when did he leave the service?
So...
Not sure we know exactly.
He was...
A year later or so?
He was suspended in late 2020, I have to find the correct date, and then he retired in 2022. Mr. Alnogan gave us the date earlier on. And therefore...
Yes, he did, sorry, you're right.
I don't know when...
Right, so he was writing pre-action letters sort of mid-2020.
Yes.
So he knew that there was a claim if he wanted to bring a public law claim at that time.
Yes.
And he had the opportunity to bring the claim at that time.
He did. And most...
Well, the Commission's decision was taken in April 2020, wasn't it? So then his letters were quite soon after that.
Yes, but he didn't know about
So is this right?
He didn't know about the decision then?
until he files his claim, and then it's the reply evidence, I think. That's what... is that right? Sorry.
He doesn't know about the 2015, I think.
Yes, sorry. He does know about the 2020, because he's told about that in pre-action. That's correct. Yeah. Sorry, he doesn't know about what happened.
So insofar as he wants to go back to the 20... Well, wait a minute, sorry. What was the first decision that we were about? It was May 2019.
Yes, 23rd of
May 2019.
May 2019.
And...
Well, that was when the notice was, but there was no decision by the Commission till April 2020.
No, but he knew that he'd been refused.
Refused to be considered, yes.
Yes, in the 20... So he had cause, as it were, from the 23rd of May 2019.
Right. Anyway, so
he was still pressing at that stage to be considered because he went off and did the course and so forth.
Yes.
Yes. Or at least was equipping himself for the next time.
He wrote on the 1st of December and said, I've now got the course, I'd like to be reconsidered, is what he actually said. He said, I've got the course, now please reconsider me.
At all events, just to try to understand what both sides are saying on this part of the case, as I understand it, you're saying that he did have a real opportunity to apply for judicial review in relation to both the elements of complaint, both the decision in May 2019 and the later one. Sorry, I did note it down and I've lost it.
April 2020.
April 2020.
April 20. Well, it's really July 2020 because that's when the Commission makes its appointment of Mr. Lane, I suppose. But he's aware of the meeting in April 2020. Yes, around that sort of...
At all events, as I'm understanding your submission, you're saying there was a real opportunity to him to apply for judicial review in the usual way to challenge the omission to consider him for these appointments.
Yes.
And you say that the fact that he lost isn't in itself a sign that he didn't have equal protection.
That's my basic... I don't want to go too far, but the basic problem in some of these protection of the law cases, I respectfully submit, and this is now not the time to make extensive submissions on it, but if he had won at first instance on all these points that, let's say, for argument's sake, he's going to win on now, let's just say, so the judge had found in his favour, there would be no sensible argument that he had not had full protection of the law. And what I say is you can't turn a situation where he would have had full protection of the law had the court got the right decision into a situation where you don't get full protection of the law because a first instance court gets it wrong, because first instance courts just get stuff wrong, and that's why you have an appeal.
And is there any authority on that point?
No, so far as I can tell, it hasn't been addressed. It's simply been addressed where there has been judicial review proceedings, for example, in Charles, which is at page 1786. In that case, that's where the chief magistrate had 53 part-heard cases, and then she demitted from office, and then the powers that be, I can't now remember who, but a decision was made that those matters had to start all over again, including Mr. Charles' matter. He said that's outrageous and breach of protection of the law, but he filed a judicial review claim challenging the decision that all those matters had to start again, as opposed to just continuing, presumably with the judge who'd been promoted. She didn't demit office, I think actually she was promoted, I think. Why couldn't she just come? Yes, she was sworn as a High Court judge. Why couldn't she just sit on those cases and finish them? But he lost that judicial review case. And the argument made in that case by the respondent was, well, he filed a judicial review case complaining about it, and he lost that judicial review case. But that's just, it doesn't mean he hasn't had protection of the law. And that's at paragraph 76 onwards on page 1802. And what the board says, paragraph 80, in the event judicial review did not prove to be an effective remedy as the application was dismissed, to which I say, well, I don't think, with respect, I don't think there is an answer. Of course, applications get dismissed if you think it's the wrong decision, appeal.
But this is the board speaking. What do the board say about that?
Well, that is what the board says there, paragraph 80. They say the answer is the judicial review didn't prove to be an effective remedy as it was dismissed, and I just say that that's wrong. But
the board is wrong when they said that.
Yes.
Okay.
Because
and what if they're right?
Well, if they're right, it means that how can judicial review? If they're right, it means that there's not an effective remedy where a court just gets something wrong, which is an extraordinary proposition.
Well, is it that extraordinary? I mean, if the court has got it wrong and there's then been a long delay, let's say he should have been appointed in May 2019 to this post. If the judicial review had been brought promptly and he'd succeeded, he would have been appointed within a matter of months and would have enjoyed that post. But because the court's got it wrong, he did not get the benefit he should have had in law, and he's now left the service. I mean, that looks as though he hasn't had an effective remedy in the circumstances for the wrong done to him.
Because there's no constitutional right to correct decisions. There's a constitutional right to a fair legal system. And if you think that decision's wrong...
I'm looking at Achille Charles. This is the board saying, essentially, there's a constitutional right to a prompt and effective legal remedy.
Exactly.
In that case, the failure of the judicial review, which perhaps should not have failed, meant that judicial review was, in the circumstances, not an effective legal remedy. Well, and what I'm putting to you is...
If that's right...
It doesn't look like an effective remedy here either.
If that's right, in other words, there's not an effective...
You say it's enough that there's the possibility of an effective remedy if the court gets it right.
Well, yes, because there's a legal system. I mean, this is a protection of the law. It's about protection of a legal system. If you look at the constitutional cases on fair trial rights, for example, there's never a suggestion that a court has to get it right. I mean, if a first instance trial court, for example, convicts somebody and they spend time in prison and then their conviction's overturned on appeal, they don't have a right for damages for the period of time they've spent in prison. Their right is to have the decision overturned by a high court. If Mr. Charles says that judicial review decision is wrong, his systemic right is to go and appeal it, not to complain by a constitutional claim to another court and say, oh, well, I didn't get an effective remedy because I lost a case that I should have won. That just can't be right. But anyway, if I'm wrong on that, then it's a big point to make.
I'm genuinely asking for assistance. I mean, is the complaint, does it have to be a systemic complaint, or can it descend to the details of the particular case?
It can descend to the details of the particular case, I accept that, but what I'm saying is, in circumstances, let's suppose Mr. Ramsaran had succeeded on all the points before the first instance court, and if he had been granted relief, there would be no protection of the law claim.
Because there would have then been a new process.
So in other words, you go to court with your protection of the law claim. At that stage, you've got no protection of the law claim because you're just about to get a remedy. So you plead your protection of the law case, you go to court, you say, here's my protection of the law claim. Yep. But at that stage, you don't have a protection of the law claim because you're just about to get your remedy. Right. So you only get your protection of the law claim later on appeal. I just don't understand how that works. I'm just not sure how that...
But I think one has to concentrate on what is the initial wrong. The protection of the law is the proper application of the regulations. And this is not a judicial decision. I've got absolutely no difficulty at all about deciding if a judge gets it wrong, there's no claim for damages. And but this is an administrative decision made by the Chief Fire Officer and the Commission, and on one interpretation they just got it plainly wrong.
I accept that.
Yeah.
I accept that.
And by virtue of getting it wrong, arguably, he suffered a loss.
I accept that. But what I'm saying is the authorities on protection of the law don't simply stop and start at saying the administrative body got it wrong. You don't just get a protection of the law claim because there's irrational decision-making or breach of natural justice decision-making. You get a remedy if there's that plus no adequate redress. And my point is, well, hang on. If he's got no protection of law claim when he first goes to the first instance judge, how can he then get one later if the judge gets it wrong? I just don't understand how that works. But if I'm wrong about that, I'm wrong about that. I can't conceive. If, in other words, you go along to court with your protection of the law claim, but you don't know if you've got one yet, because if you're just about to get an effective remedy, you don't have one.
But that, I don't want to take up too much time on this, but that is what happened, I think, in Achille Charles.
Well, the Achille Charles is slightly different because, of course, there you've got two different sets of things going on.
Yeah, but they contemplate that the appropriate remedy in local law was to seek judicial review of the decision that there had to be a de novo preliminary inquiry.
Yes.
I'm just looking at page 1802.
Yes.
And the board identifies, in fact, right, that was the only relief that was potentially available, and it was potentially available, but it wasn't effective because the application was dismissed.
Yes.
It's dismissed by a judge. So
Yes.
This was Lord Hamblin, I think.
I had to pick that up, right.
And Lord Burrows.
Right, well, yes, well, obviously that makes the submission that it's wrong one that we'll have to consider very carefully, but...
I'm sorry, I appreciate it's a big submission to make in a very small amount of time. There's
anyway,
lots of stuff.
My question really was, what's your position? I think we've got your position.
Yes.
Ask for, do you want to refer to any authorities? You've referred us to an authority,
yes.
which on one view is against you, but you say not. I think we need to draw your submissions to a close now. Is there anything else that you wanted to deal with before you sit down?
My Lord, I don't want to do everything. I would just highlight to your Lordship, I'm not asking for more time to do it, but I haven't dealt with the equality claim. But I think I say what I say about it in my case, but if your Lordship wants me to say anything about it, I will, but otherwise I'll just sit down.
Right. Well, I think in fairness to you, the equality claim was not significantly expanded upon in
No.
Mr. Ramlogan's oral submissions.
Thank you.
Unless there are any other questions? No. Thank you very much.
I'm very grateful, thank you.
Yes, Mr. Ramlogan, you have your 15 minutes to reply.
It will be me, my lord.
Oh, right. Okay.
15 minutes. I will do my best. What I would like to do is just try and clarify some of these points. And I'm going to just refer you really back to our written case for a lot of this, which has tried to separate these issues out into 5 separate areas in the hope of making a bit more sense of the factual details and the claims that arise. Just going to issues 1 and 2, which
you have
are
to
around...
remind us of what those are.
Yes, the 5 issues are set out in the Statement of Facts and Issues, my lord, which if you go to page 1049 of the bundle, or
Yes.
you have got that on the printed case anyway, haven't you? That just sets out the issues in the appeal there. It is loosely what we've been following, but
Yes. Thank you.
just to give some structure really to how to use these 15 minutes. Issues 1 and 2 relate to the job description to a certain extent in this way. The appellant's primary argument is that he was simply eligible in accordance with the public service regulations, Regulation 158, and the eligibility requirement in there, because he met the qualifications set out in the fire service regulations, namely Regulation 9, and the requirements in there.
Can you just remind me of the page number of Regulation 9, if you would?
Have I written it on my note? Thank you so much. And I would invite your lordships to have a look at the regulations set out there prior to Regulation 9, because they do demonstrate for each of the roles within their fire service what qualifications are required. Those regulations refer to examinations, and they refer to qualifications.
What are you referring to now?
Just regulations 1 to 9 generally, because they show you each of the different posts up to
Well, I
that
think it's
point.
accepted by the respondent that eligible in the statute is a reference to those qualifications.
Indeed, my lord, but
Yeah.
I think the point I'm trying to press here is if there was a particular requirement to comply with a particular course, this is the place where it should be specified.
Right. I mean, I think that necessarily follows. If eligible requirements is a reference to here,
Indeed.
then it follows.
Because the International Brigade Command course was not specified in Regulation 9, we say it cannot fetter the decision-making of the Commission to apply all of the considerations in Regulation 158. The same is true of the experience requirement being set at 6 years from whichever point is your starting point. To clarify, it is not our case that we say the job specifications were ultra vires. The case is that the specific requirements in there, which the respondent says are concrete or black and white requirements, cannot impose a threshold eligibility requirement. And I choose that language from Lord Sumption in Ramatar. And I know, Lord Sales, you've said that it's not, it's distinguishable because it refers to Regulation 26. However, I would refer you to paragraph 26 of our case for this, the case law set out there. There are 3 cases that deal with this point across the different regulations. Ramatar, Singh and Boland. Ramatar deals with Regulation 26, as does Boland to a certain extent, and Singh deals with Regulation 18.4. For each of those regulations, the courts determined that these created a discretion to the Commission, or indeed the particular service, because as your lords have been discussing, there's an issue about who sets the requirements. In Regulation 26, as the court points out in Ramatar, there is a general rule of seniority that applies to other areas of the service provision. That general rule can be displaced by particular requirements. In Singh, it is Regulation 18.4. Regulation 18.4 creates a discretion to provide other requirements. Those regulations do not apply to the fire service. It has its own statutory scheme, and it is between the fire service regulations and the public service regulations within this particular chapter where Regulation 158 is set out. There is nowhere between either of those sets of regulations that provides for additional criteria or discretion to impose additional criteria, or as I use the words, threshold eligibility.
Right, but why doesn't Regulation 1581 do that if it's the Commission doing it? So if the Commission attaches particular importance, let's say, to a particular qualification being held, if someone's going to be appointed to a particular post, why could the Commission not make that clear, that it was going to approach its decisions about promotion on that basis? Because
it isn't the role of the Commission to determine what the requirements are in a post. And if I take you, my lords, to Boland on this point, it's page 186, paragraph 28, the court here looks at the...
Page what, sorry?
1868.
1868.
Yes. The court looks here at how the job specification came to be created. It is between the personnel department within the relevant ministry and the service commission, that's not helpful, is it? The particular service. In this context, it was the prison service. So it was between the prison service and the relevant ministry. Here it would be the fire service and the Ministry of National Security. It is for that department to create the requirements in office. The Commission's responsibility under Section 121 of the Constitution is to appoint people. It is not to specify the requirements of the role. It can only do that in accordance with the regulations it is given.
Sorry, which provision in the Constitution?
Section 121, and I'm so sorry, my lords, that hasn't appeared in the bundle. You've got 129, which
All right,
doesn't.
we can look it up for ourselves.
Yes.
You go on.
So what we're saying, my lords, is that the job specification cannot itself create that threshold criteria. And it can't do so because, as it says at paragraph 16 of Ramatar, there is no statutory basis to provide that threshold criteria. We're not saying that there's no value to having a job description. They're obviously useful, but what it can't do is say this imposes specific criteria to the exclusion of all the other experience and qualifications that a person has, as are categorised in Regulation 158.
But why not? If the Commission, in exercise of its discretion under Regulation 158, actually does think it's extremely important that someone being appointed to this role should have a particular qualification, why can't it give effect to that view that it has formed?
Well, as I say, it's not for the Commission to form that in the first place, although as I accept,
You say that,
there's
but
a job
it
specification
is for the Commission
here.
to actually decide who's going to be promoted.
It has to weigh the relevant criteria, I accept. That's the purpose
So I
of
come back to
Regulation
my
158.
question. If in weighing the relevant criteria, it thinks it's super important that someone has this qualification, why can't they give effect to that view?
It can do so if it weighs them, is the distinction that is made in Ramatar. What it can't do is use a particular requirement to exclude everything else that the person might have. In this case, there's no evidence that all of the other experience and qualifications that Mr. Ramsaran held were considered. We draw analogy with the Ramatar case because we say it's imposed as a threshold eligibility criteria. Nothing else is considered. And we get that from paragraph 18 of Corey Harrison's affidavit, in which he sets out the minutes
He describes the meeting.
the meeting. And again, we don't have the minutes, so we only have his summary. We don't know the fullness of it. But what that note seems to suggest, and it's at page 888, my lords, for the reference, there was no 6 years, so that's it. We don't look any further at him. We say that's wrong because that is not in accordance with the requirements of Regulation 158. It is a mandatory requirement. It says shall take into account each of the considerations, not only one. And unless there is evidence to suggest that they did that, which is not before the board, then it is an unlawful decision. What are the consequences for the Public Service Commission in job specifications in other cases? This was raised by my learned friend. Again, I'd refer you to Ramatar on this, where Lord Sumption considers it at paragraph 19. That's page 2162. Firstly, in this case, as I say, there is no actual discretion within the regulations to do so. If this particular service commission wished to have this opportunity, it can amend the regulations. They're amended quite regularly because ranks change all the time. It's amended in 23, 2012, 2006, and down the line. It is easy to amend the regulations to create a discretionary provision. They're not there. Ramatar says it would be much more concerning to simply pick and choose from a job description as to which are the most important, without having any statutory basis for how that is done.
Right. Well, I'm not sure where that takes you. Because if you look at Regulation 1581, it sets out some highly open-textured factors, all of which can be taken into account in basically an unstructured way. That the regulation doesn't give you a structure.
My Lord,
One might think that
yes.
a sensible employer actually, when trying to make concrete decisions, would try to give it some structure within the ambit of Regulation 1581, rather than just say, oh, what shall we do today?
There is an argument for that, but my primary argument, as I say, is that there's no power to do that. And secondly, if the exercise under Regulation 158 is properly followed, there will at least be reasons setting out what qualifications the person holds and experience have been taken into consideration and how they've been weighed. So, for example, Mr. Ramsaran has a master's degree in a relevant area. Does that have any bearing on the fact that he doesn't have an IBCC? And why would that have a bearing? There needs to be a reasoned decision, is our argument.
I don't think that there does need to be a reasoned decision. There isn't an obligation to give reasons, is there?
But if a person isn't appointed, then they can ask for those reasons.
Can they? Sorry, where
Well,
can they do
I'd
that?
just say, on general public law principles, surely that has to be right. You know, if anyone who isn't appointed
But
in
your
a post
primary
can ask
point
for
is that under
feedback.
158 they're obliged to consider all these matters.
Yes. Thank you, my Lord. Just moving on then to issues 3 and 4. This is about the 6-year period, because this was a real sticking point from the point of August onwards. If Mr. Ramsaran is eligible from August 2019 onwards, why is he still not appointed? There's a question about where the First Division begins. My Lords, if you look to the schedule to the Fire Service Act, that First Division is set out in the second schedule at page 1581. And it shows that it is the Assistant Divisional Fire Officer who commences that First Division. Our argument is that a distinction between the First and Second Divisions, logically, that is on seniority. The job specification doesn't say on its face, as we've discussed, where the starting point is. And it's been submitted to you that the settled practice is that it's the divisional fire officer. Our case is that there's no evidence to that effect. There are 5 pieces of evidence that try to address this, but none of them actually conclusively do, because they conflict. And this is why Justice Mohammed made the determination she did that it is appropriate to look at the schedule and the First Division for where that office should commence from.
Yes.
Corey Harrison.
I have to ask you to wind up.
Yes, thank you.
last
My Lords, I've set out that evidence within the case for you to consider in any event. But just to say, which is not set out there, the only piece of evidence really that tries to address this question is referenced in Corey Harrison's affidavit. It's paragraph 30, page 892, where he indicates that in 2009 there was a question raised of the Chief Personnel Officer to interpret at what rank of the First Division does senior managerial experience commence for the purpose of the Divisional Fire Officer. The answer, because the question was about that office and the Chief Fire Office, only came back with Chief Fire Officer. So there was still no answer on that point. There is a job description for the ACFO, which you've been directed to, which says that the DFO is the starting point. But of course, that was not applied. So as far as Mr. Ramsaran was concerned, it didn't create a condition precedent. And indeed, that was in 2016. Matters may have changed since then. We have no evidence on it.
Yes, thank you very much.
My Lords, just to emphasise, if I may,
Well, if it's a point of emphasis that's been covered already, I think you don't need to reply on it, and you have gone over your time.
In which case, thank you, my lords.
All right. Thank you very much. Thank you. The board's grateful to all counsel in this case and everyone in the legal teams that have assisted in the preparation of the written submissions. The board will take time to consider their judgment. This hearing is now adjourned. Thank you very much.